Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass, Chris Hallett, and of course, John Gentry. Kirk is on location right now, so Chris is going to start up the show. Welcome, Chris.
Hey, what's going on, Ted? How's it going? I'm just sharing here a little bit, and since we got this bad rascal going, tell us what's going on, Kirk. Kirk, where you at, brother?
I am tidying up, finishing up a Subaru head gasket job. Timing set, whole 9 yards.
Nice.
Water pump. Tie rod in or tie rod in. Fun stuff. Doing that, work type stuff.
Oh, yeah. You're not bashing any fingernails or throwing any hammers or wrenches across the shop, I hope. All right.
No, I did smack the back of my head last night, though, on my little wooden toolbox here.
Ouch.
Going to lay down on the creeper and smack the back of my head. Other than that, I ain't even drawn blood yet, which is quite amazing.
That's one of the 7 danger signs you're doing it too long. When you don't have bloody knuckles or something, man, I'm telling you. It's like I'm either getting really good at this or they're getting really bad at it. One of the two.
Yeah,
I've done quite a few of the Subaru jobs.
Oh, yeah?
What's that, Ted?
Every time I work on my car, I get bloody knuckles, I was just saying. And did you know there's also a game? We used to play a game in high school called Bloody Knuckles. You guys ever play that?
Oh, yeah, where you slap each other's hands?
Oh, yeah.
With the cards.
Yeah.
It's a card game. And if you lose,
Yeah.
you either get a hits. If you get a black, like the clubs or the spade, it was a hit. You take the, nobody can see me. You guys can. You take the cards and you hit the knuckles with the cards. If you get a red, a heart or a diamond, it's a scrape, and you take the cards and you scrape. I don't know what possessed us to do this in high school, but we would actually, inflict wounds on our knuckles playing this freaking game.
Ouch.
Yeah, remember, we didn't have internet. I went to high school in the 90s. We didn't have internet yet. There was no Facebook to waste all our time or smartphones. So
right.
we did things like, all right, what are we going to do now? We all wanted to hang out. And, we didn't play a lot of no friendo and stuff. We were...
Yeah, well, that was back when people were smart and phones were dumb. Remember those days?
Yeah. Yeah, that was... I don't think even anybody I knew or nobody I knew had even those giant car version cell phones back in the 90s. They had no reception way up here.
All right,
anyways.
John says he's waiting on the host for you to let him in.
There he is. Admit. All right, let me get rid of this camera and we'll be golden.
The way we used to play Bloody Knuckles was straight fist to fist, and you reached up and hit him on the knuckles with your other knuckles. That was Bloody Knuckles for us. That was in the 80s.
Yep.
Maybe they got too wussed out and said, "Oh, well, we'll use deck of cards instead of smacking knuckles."
Right.
I don't know. Well, remember, I grew up at the college where Animal House was based on. The film Animal House was based on two frats, Herod and Alpha Delta AD, we called it. That movie, Animal House, was based on that frat. So that kind of tells you how much time we had on our hands.
Right.
You know what I mean?
Oh man, I'll tell you, I'm so lucky that YouTube wasn't around when I was a kid.
Good times.
Can you imagine how much trouble I'd be in right now?
Oh my gosh, yeah. Yeah, we all should be worried about our kids because everything.
Yeah, there wasn't anything such thing as an
You're breaking up again, Kirk, really bad.
Now they had intranet.
He's breaking up. You're breaking up, Captain.
Yeah, you're not going to be able to work on your car at the same time. I don't think you're going to have to step outside or whatever.
Man,
but you do what
how
you
about
want
now?
to do.
Can you hear me now?
I can hear you okay now. The video is almost as skippy as Chris's video always is, because Chris needs a new computer, a better Wi-Fi connection, and a new webcam.
Yeah, I got that ghetto thing going on there. I haven't spent a whole lot of money on this because, we never know how this is going to end up. So,
yeah, I think.
How you guys doing tonight?
Hey, John.
There's John. What's up, brother?
Sorry I'm late, guys.
It's all right.
Oh, that's okay. We're running behind, man. Every one of us.
Hey, whenever you guys are ready, I got some really fun stuff to share out of the Sixth Circuit.
More fun stuff. I know. I've been dealing with these reports, getting the, 1,500 and some odd godly pages into, 9 different houses of Congress. And it's like, oh, Lord. So.
Kirk's still on us, huh?
Yep, Kirk's
I'm
on
here.
the phone.
I'm working. Yeah, I'm working on a car. All I have really left to do now is throw the wheel on it and get it down off the jack stands.
Brian goes, "You're still in trouble, Chris. It's getting interesting." Yeah. Tell me something I don't know, Brian. I'm always in trouble. Matter of fact, I'll type that in here so everybody will remember it. Just because. Or should I say I'm always starting trouble?
No, you don't start anything.
I don't know.
Chris,
Trouble's in there somewhere.
Yeah.
All
you do, Chris, is help people.
Well, that's what I try to do.
Yeah.
You don't deserve a hard time from anybody.
Yeah. Hey, dude. You know what they say? No good deed ever goes unpunished, right?
I thought.
Right.
Yeah. That saying is actually a little bit different, but when you're in Facebook land, then that's exactly correct.
Yeah. Oh, there's always somebody out there trying to take your work, pervert it. Whatever. It's just whatever.
Yeah.
Can I share this one with you guys? I'm like chomping at the bit this one. So
oh, dude, go to it, brother. Go to it, John.
I was going to say, why don't we have John?
What's that?
Do his thing there, and I'm going to jump off real quick, throw this tire back on, get a hold of the gal, and I just told her, she just texted me back. So, yeah, run with that, and then I'll get this done, and I'll jump on when I get back home, and I'm just a few blocks from home. So,
all right,
sounds like a plan, brother. We'll hold the fort down for you.
All right, can you guys?
I'm perfectly comfortable with that.
All right, bro.
I'm confident that you guys can hold down the fort.
Rock and roll.
Oh, much love, folks. I'll be back shortly.
Why don't you just set up the phone and so we can watch you change your tire while John's talking?
Can you see my screen? Okay.
Yep. I can see it.
Got you, John.
So this is a recent order that I got from the Sixth Circuit in my case seeking reform against the state of Tennessee. And and this is important for anybody that's taking action against the state bad actors, against the state, is always request an evidentiary hearing. I think few people do this. And if you don't request an evidentiary hearing, they can just decide your case on the papers. But if you request an evidentiary hearing, they're supposed to give it to you. I mean, that's part of due process. If you look at Federal Rules of Civil Procedure, Rule 8, it just says, you got to state a claim of action, a cause of action, the redress that you want, and some basic elements that establish that you have a cause of action. And it's like, you can write up a skeleton complaint based on Rule 8, and it should be heard. But they, and then you should have a chance to present your evidence in an evidentiary hearing. But they deny that in federal courts. And so, Chris taught me early on, attach your evidence to your complaint. But I still asked for an evidentiary hearing because there was more evidence that I wanted to present, and the district court magistrate denied my motion. I objected to that timely within 14 days as required by federal rules of civil procedure. And the district court judge denied or upheld or denied my objection, overruled my objection. So I appealed that issue in the Sixth Circuit, and I was like, I was denied due process. I should have had evidentiary hearing. So Chris, you're going to love this one. You're going to absolutely love this one. So Sixth Circuit came back and says, Gentry contends that the district court should have gave him an evidentiary hearing. This circuit has long held that a district court does not abuse discretion by dismissing a complaint without first hearing an oral argument. Klein v. Rogers, Sixth Circuit, 1996. Now, here's the thing I want you guys to learn out there, is just because they say something doesn't mean it's true. Just because they cite a case doesn't mean that case is supporting authority, or that it's correct, or that they did not misrepresent that case. So I always go and research and say, okay, well, the Sixth Circuit's saying they've long held this, and go see Klein v. Rogers. So I went and looked up Klein v. Rogers. Here's what I found. Chris, you are absolutely gonna love this one.
Yeah.
This one just astounds me. Trying to get to a single page here. Can you see that okay?
Yeah, blowing it up a little bit.
Bigger?
Yeah, a little bigger, because remember, people that have small screens will strain to see it. So
how's that?
That's better.
Okay. How's that? Is that good?
There it is.
Okay. So under the federal rules of civil procedure, Rule 12I says if a party moves for any defense under 12B 1 through 7, and that's what they do. They always file a 12B6, right, Chris?
Sure do.
Failure to state a claim. So if a party moves any defense listed under Rule 12B, whether by pleading or motion, and a motion under 12C, must be heard and decided before trial unless the court orders a deferral until trial. So the title of Rule 21 says hearing before trial. What's a hearing? Barron's Law Dictionary defines a hearing as a proceeding where evidence is taken. That's a hearing. Rule 12B or Rule 12I, the title of it is a hearing. Clearly a hearing is a proceeding where evidence is taken. So again, going back to Rule 8. So this is what Rule 8 says. Short, plain statement of the grounds for jurisdiction, a short, plain statement of the claim, and a demand for the relief sought. So you should be able to write like a really simple complaint and you should be heard, right?
Correct.
But no, that ain't the way it works. Not when
but of course not.
Not when you're going after bad actors, right?
No, they don't. No. That's we didn't hear nothing. See no evil, hear no evil, speak no evil, do no evil, right? Just saying.
So here's what the court said in Klein v. Rogers. In that case, it was Judge Batchelder who circumvented the intent of Congress, I believe, in dismissing another case that I had against Judge. So Judge Batchelder said it was not an abuse of discretion for the district court to dismiss the complaint under 12b6 without first hearing oral argument. well, wait a minute. 12BI says that the court must have a hearing. But she's saying it's not an abuse of discretion. And then she cites Mann v. Cohen, and she cites Federal Rules of Civil Procedure 78. Now, Chris, this is where it gets crazy. In Mann v. Conlon, they said it is within the district court's discretion to expedite a case by ordering submission. Get this, by ordering submission and determination of motions without oral argument. See Rule 78. So what Rule 78 is, and you got to go back in time for this, and you guys know I do my research, right?
Amen, brother.
So Rule 78 came around from Equity Rule 6. The equity rules were pertaining to civil cases before the Federal Rules of Civil Procedure existed. This is back before 1938. And going back to 1938, Rule 78 was motion day. That was that. So remember, back in 1938, we didn't have federal courthouses. We didn't, they didn't have regular days that federal cases would be heard back in that time. And so, so the federal rules, when they first came out in 1938, it said, unless local conditions make it impractical, each district court shall establish regular places and times at which motions may be heard. So that's motions day. You district courts, you got to set up one day, where you're going to hear motions, or regular times and places. And then they went on and said, by rule or order for determination of motions on the briefs. So that means you can also, the court can have a local court rule, by rule, they can have a local court rule, or the court can issue an order and say, on this day, you can submit your briefs or your motions just to be heard on the briefs. Like you don't have to come in and argue these things if you want to just have the judge decide on the papers, right?
Yep.
Motion day. That's what Rule 78 was originally known for, was motion day from 1938 because we didn't have federal courthouses. So they updated the rules. Our present, I think this is December 1916 or November 1916. So they changed the title to provide regular schedule for oral hearings, and it says the court may establish. So remember, back in 1938, it says they shall establish. So now they said they may establish, and they did that because they hear motions all the time now, right?
Yep.
Electronic. We don't need motion day anymore.
Right.
They changed it and said, well, you may establish. And then for submission on the briefs, they added this piece without oral hearings, and they said by rule or order, the court may provide for submitting and determining motions on the briefs. So what that means is if the court issues or sets up a court rule, or if there's an order issued, then they can determine matters. This rule is not about denying due process in evidentiary hearings in any way whatsoever. Would you agree, Chris?
You're absolutely correct. And right where you're going is right what we did with Nate's case in Texas. This is hilarious. Absolutely hilarious. So
So I went back in. So the Sixth Circuit said that it is not an abuse of discretion for a magistrate or a federal district court to hear and decide a 12B6 motion, failure to state a claim, without hearing oral argument when 12BI clearly says that they shall conduct a hearing. And these guys totally, I think, in my opinion, I believe that the Sixth Circuit has misapplied an administrative rule intended for the administration of the courts, not to deny due process. And my argument, I came back and said, this is not a matter of an abuse of discretion. This is a matter of a denial of due process. This is denying us the opportunity. Remember, if they go back to Rule 8, you just got to lay out a simple complaint. Say, you have jurisdiction. Here's the facts, and here's the redress that I want.
Yep.
You don't have to state the facts. That's what trials are for.
That's right.
but these guys, they misconstrue it and say, well, we can decide these things without granting you an evidentiary hearing, and then they come back and say, well, his arguments are conclusory and unsupported. Well, of course they're conclusory and unsupported because you didn't give me a hearing to present my evidence. This is
right.
crazy. What's going on in our federal courts and
yep.
not protecting bad actors in the state.
Right. So we go around a bunch of those loops and then they put you right back to the beginning, right? That's exactly what their rules are designed to do, right? Keep you in this bullshit process based on a bunch of rules that do nothing but take you back to the beginning. You do it again, take you back to the beginning, and you never actually get due process. And based on these rules, they're saying, well, because we gave them some of these loop-de-loops, that's due process, that counts. No.
No, it doesn't. The Supreme Court said in 1972, Haynes v. Kerner, this is a really good case for you guys out there, whatever the limits of scope of the inquiry, allegations such as those asserted by the petitioner, however inartfully pleaded, are sufficient to call for the opportunity to author supporting evidence. Accordingly, although we intimate no view on the merits of the allegations, we conclude he is entitled to offer proof. The judgment is reversed and the case is remanded for proceedings consistent herewith. Our Supreme Court has said that we should have evidentiary hearings and be able to offer proof of our allegations, but the district courts denied that opportunity, and apparently the circuit courts affirmed that denial of due process. Crazy stuff, man.
Ironic. I have Haynes versus Turner incited in my report.
We're usually talking about the lower courts and how the lower courts are creating their own legislation.
Right. Well, so they're not so much creating legislation as they are creating fictitious rules of procedure.
Where this is wait a sec. But this is a federal court case. This isn't the lower courts.
Right.
No, this is in the United States. Sixth Circuit said that.
That's the state.
Right. So this is the federal appellate court. The Sixth Circuit is saying this, not the lower courts.
Yeah.
So how? Usually the federal courts are where you find justice. So this is a little disheartening, disconcerting.
Well, now you heard me down in Georgia, Ted. Misconduct by judges could not occur if judicial oversight agencies were doing their job. Misconduct by members of the judiciary could not occur if the federal district courts were doing their job. The fact that it happens means that the judicial oversight agencies and the district courts are not enforcing the Constitution.
Right.
You cannot, the fact that there is judicial misconduct, and we all know that there is, the fact that it occurs, it has to be true that the district courts and the judicial oversight agencies are not doing their job. If the judicial oversight agencies and the district courts are doing their job, this crap wouldn't be happening to us.
Yep.
Now for the district court to wrongfully dismiss a case, it has to be true that they know that the circuit courts are going to affirm that, or the district courts wouldn't be doing that crap and dismissing cases wrongfully, right?
Correct.
So it has to be true that the circuit courts are coming up, and here I think is a pretty clear example of how the circuit courts are affirming denial of due process. And I believe that, and I think if you take this a step further, for the appellate court to make this kind of ruling, and Ted, I think you agree with my argument here, don't you?
Oh yeah. Well, that's the thing is early on, when I realized that both men and women are victims, it doesn't matter. It's not just men. It's not just women. And CPS and family court, it's all tied together. I realized about a year ago that, or I didn't realize, but my theory was, well, is the Supreme Court at fault for not knowing the law? I'm thinking, aren't the Supreme Court supposed to be kind of controlling this? Maybe not. I mean, We have
exactly.
We have a Supreme Court of appointed justices, not elected, so that the law doesn't sway back and the political winds. But that has created a group of people who have, you know, they don't have to answer to anybody. And now we've got the lower court system completely run amok, just like Trump and Sessions have said. And we all knew this. I mean, the fact that even Trump and Sessions realized this is such a breath of fresh air, and is worth my vote just right there. I'll tell you that much.
Right.
But
yeah. So for these guys, you know, and I can tell you, I've got a couple cases, getting ready to work on another one in the United States Supreme Court, and it is not easy, man.
No.
You know, to print the booklets and the number, you know, 40 copies of these booklets. I got a quote from a company. They said to transform my 8.5 by 11-inch papers into booklet form, $3,500.
Right.
To do that. $3,500.
So, like, you do this thinking that maybe they'd shut you down. You think that was a possibility?
Yeah, it's very difficult. I mean, who can print on 60-pound paper on their home printer?
Yeah, it's not easy. I can, but it's not easy.
So
that's
breaking so the circuit courts know that it's too difficult just to even file. And then when you do file, I don't think that the Supreme Court grants certiorari.
Right.
I think that's why this stuff happens. They're like, oh, that's just court error. We don't care.
Right. And here's what it boils down to, guys. Having been through every one of these processes, which we all know is smoke and mirrors, okay?
Yeah.
I took and I created something that we do in private sector, and we say, okay, well, we know what the system says, right? We know what it's designed to do, but what it's doing is it's not doing what it's designed to do. The end result does not look like what its intended purpose was. And here's how we know this. And of course, I went through and I did all the math and, you know, showed them the whole thing. And one of the uniqueness, the unique perspectives of my particular case is I broke it down to the events of one day, just that one day. And from that point on, I was able to clearly establish, you know, where it is in law. And the problem with it wasn't that this was not conclusive, because it's very conclusive. The fact that it's taken almost a decade to actually get right back to where we started to begin with, this loop-de-loop issue is the problem, right? That's the weaponization, to make you go through this, just take you all the way back to the beginning, and they run you through it so many times, they want you to quit, right? So basically, I went through and worked all of my cases, and I've been able to break it down to, and this is just the cases that I'm working now. When I sent it off, I had an appendix on one paper, just one page. So when it comes to how you make your presentation, that's everything. Because if you can break it down so simplistic, so stupid and so simple, that you can put it on one piece of paper, that in this section, you're going to see this document. In this section, you're going to see this document. And here's the, you know, whatever the authority is, and like the treatise of false arrest and imprisonment, treatise of impeachments, et cetera, et cetera. So, you know, I've basically provided them with the answers that they already knew, because these things have evolved over the course of time. So it's like, well, you know, when it comes to asking courts simplistic questions, I don't have to ask the court if we can lie. Guess what? The 9th commandment says that. The law says that. So there's no point in even bothering the court with this. This is not an issue of judicial process. This is an issue of abuse of judicial process, that they've tried to usurp the law through a subversion of this fictitious process that they've created so that they could make money. And we know why they did it, right? You know, John, you wrote that, you read that book about the fraternity, right? Which I did copy. I'm about a third of the way through it. I haven't gotten all the way through it yet, but
good book, isn't it?
Yes, it is. Very good book, and very insightful. Yep. So, you know, when we talk about, you know, we haven't actually evolved over time. We've devolved over time. So when we talk about the construction of life, liberty, and happiness, in other words, you can go do whatever the hell you want to do. If you want to practice medicine, go practice medicine. You want to go be a rocket scientist, go be a rocket scientist. Nobody gives a crap. But now, because they've got everything tied up and everybody is, you know, they're trying to say that there's this civil liability. Somebody walks into John's cake box shop or whatever on a rainy day, slips and falls on the floor, cracks their head open. Now all of a sudden that's John's fault. No, it's not John's fault. It's not John. John was back in the back cooking, making cakes. They have no control over an act of God. That's rain, you know. So, but because they've constructed these fictitious processes to do all of this crap over the years, so they can emolument, make money, right? Well, guess what? That's not going forwards. That's going backwards. That's why when I decided, I said, oh, I'm going to go back to the Declaration of Independence. You know, we hold these truths to be self-evident. In other words, I don't need you to tell me this. You don't need me to tell you this. It is what it is. And they went, yeah, you're right. So now what do we do? Well, here's the answer. We do what they did in the beginning, right? You take this crap, you crumple it up. That's how you handle it. Yeah. That's what they're working on. They're like, you know what? You're not wrong. This is what they're doing now. They're taking these, they're going to throw it up, and they're going to get rid of it because they figured out there's a better way to make money than trying to force people to do crap based in law. You know, we talk about mandates, policy and procedure. My favorite joke is you got a Target employee and a Walmart manager walks in and says, Target employee has to follow Walmart rules. No. Even Congress is like, well, yeah, talk about self-evident. Well, guess what? That's exactly what the hell's going on. Quit doing it. So, you know, now we're starting to see stuff come out about how it actually got constructed. And it got constructed, you know, for any number of 100 reasons. You know, it was, whether it was coercion, which we're finding out a lot of times it probably was. You know, hey, so-and-so, here, I'll give you so-and-so, so many more, you know, so much political clout, and I'll give you so much for your campaign if you sign this piece of legislation. And by the way, if you don't, I'm going to send out a smear campaign that's going to appear on the front page of the New York Post tomorrow morning. That poor bastard's in a rock and a hard place. He can't wave or salute. So, you know, it's...
Here's the tricky philosophical part of this, Chris, is, you know, they come under this guise of looking out for the welfare of the people, you know. We're protecting the people, you know. Slip, fall, you know, he should have cleaned his sidewalk.
Yeah, whatever.
You know, our legal principle used to be based on caveat emptor, buyer beware. And the legal profession totally flip-flop that, and they take all responsibility away from individuals, and transfer that responsibility to businesses, to other individuals, and then they say, you know, oh, well, if you screw up and you don't clean your sidewalk or whatever it is.
Then you're not responsibility.
They don't care. They don't care that person slipped and broke their ankle, wrist, or whatever. What they care about is extorting somebody under color of law.
Right.
Saying, you know, oh, we've come up with this new tort, this new product line. And so now we're going to use this new product line to generate revenue for the legal profession.
Right.
And allow these torts so that my attorney friend can get 40 to 60% off.
Yep.
And society thinks this is a good thing when it's nothing but extortion under color of law.
And that's exactly correct. So again, that's why I said we've devolved back into parliamentary practices, because what they've effectively done is they have, completely taken our core concepts of practice, okay, and perverted them and weaponized them into stating that, like you said, Ed, it's no longer buyer beware. It's your person, Mr. Business Owner or Mrs. Business Owner, you're liable for everything. And we're going to create this thing and call it a tort, right? So now when you're talking about bad business practices, yeah, you should be, at least have clean working conditions, and because that's where all this stuff started, right? You're talking about factory workers that didn't have reasonable
balance.
conditions.
There's a balance for sure.
Right. And so when all this stuff started, it was a good idea. The problem with it is, like everything else, it has a potential to become abused. And that's where we are. That's why I said we've reached that point where they've abused it. And now it's gotten so bad that you have an entire classification of people that believe, oh, we're entitled. Wait, you're what? No, the only thing you're entitled to is what you earn. That's kind of the point of life, liberty, and pursuit of happiness. I just get a charge out of the work. Always have.
Yeah.
And, come to find out it's, that work that I was doing, these sons of bitches were taking it and using it against people. When I found that out, it pissed me off. Right. I said, no, you're not. And, I got that letter from Ohio. They're threatening to go after my ex. I said, no, you're not. We've already had that conversation. And if you do it, I will come there and I will destroy you in court. You know it and I know it and I know it. So don't even try it.
Yeah.
So I'm waiting for their response.
Yeah. So that book, I just posted the title of it in the comments.
Mm-hmm.
And I encourage, to understand what has happened to this country because of the legal profession. I encourage the viewers out there to go pick that book up and read it, The Fraternity, Lawyers, and Judges in Collusion. It was written by Judge Malloy, who he was the one that wrote the Miranda rights opinion. You have a right to remain silent. Anything you say can and will be used against you. He was the Arizona appellate court judge that wrote that opinion. Very respected member of the judiciary. And at the end of his life, he wrote this book as a confession about what's happened to the profession. And Chris and I were just talking about, how they've introduced new product lines for the business of law. And those product lines are these torts that they fabricate, and the judges follow along with them. So these guys can get 40% of a $20 million settlement or a $20 million award from a jury, which is
right.
I think a lot. I mean, some of these are good. I agree, but a lot of these are just basically extortion under color of law, based on unconstitutional statutes and misapplication of rules. And now what they've done, and Judge Malloy talked about it in his book, the rules of procedure were put in place to complicate the process so that we couldn't ourselves go to the court, and that we needed attorneys to come represent us. And so the rules of procedure were not there for so much for orderly proceedings as they were to complicate the process. But now what they're doing is they're putting rules in to confound due process. I think I've mentioned on the show before, Middle District, Tennessee has a local court rule. In any case which one of the litigants is pro se is exempt from customized case management. That law denies equal access to the courts, and it's unconstitutional.
Right.
and these are littered throughout the rules of procedure. There's crap like that all over the place, and nobody challenges it, and they just let it go. And then, if you're watching the show earlier, how the Sixth Circuit, I think, has totally twisted the motion day rule and used it as a basis for denial of due process. So now the next progression of what's happened in the legal profession, instead of introducing new product lines, new torts, instead of complicating rules, what they're doing now is turning to criminal pursuits, turning to vexatious litigation, turning to violation of constitutional rights, turning to ignoring perjury that routinely occurs and not sanctioning it when it's been proven perjurious. So these next steps that the profession has taken makes you ask the question, because this thing hasn't stopped. They went from adding all the rules to creating new torts. Then they go to vexatious litigation. Now they go to rights violations. Now they're taking children based on unsupported allegations. Where the heck is this thing going to go next if we don't start to stand up and fight this crap? What's going to happen next? I can't hardly imagine. I mean, I can't imagine it getting worse, but it seems to me that it has to get worse because of how it's evolved, or as Chris put it, as how it's devolved over time. Astounding.
Yeah. Yeah, it just absolutely amazes me. I mean, like I said, when I started doing this, it was, remember, I've never had any issues with courts, with law, I was just a guy doing his job. And so that's who I am. And then when I started to see exactly how bad things had gotten, it was like, okay, that's it, timeout. And come to find out, the swamp, right? They don't want timeout. They want their constructive fraud. Well, guess what? People stepped up and said, no, you are not. The Supreme Court has even said, no, you're not. And when it comes to altering our founding documents, not going to happen. So when it comes to issues of constitutionality, I said, well, look, we're going to start with equal protections, meaning equal practice. And they said, wait, what? I said, well, let's just talk about equal protections, defenses. Let's start with defenses and go from there. And we established that, yeah, there is inadequate defense, major inadequate defense. So much so, our first run at this resulted in a 90-day decision clearing one guy's name. Guess what that did to him? He's back on the, he's back in good standing again. And that's a good thing. That's exactly what needs to happen. So we're able to show that the documents in the Constitution as they're written, they work just fine when followed the way they're written and when practiced as they're written. And this was not an issue of we're looking for culpability or we're looking for liability. That's, leave that to, Uncle Numbnuts over at the bar, because guess what? If there's going to be some form of liability there, if he doesn't find it, he'll make one up. Oh, gee, we're shocked. Okay. So we said, we're just going to leave the liability out of it for right now. And we're just going to talk about basic human rights. And of course, they kept listening. And the more we did this, the more the swamp monsters came out and, took these different swipes at us in the different states. It was one attorney general called it a skein, which was basically implying, look, we know where the swamp is and it's a political clusterfuck and blah, blah, blah. And yeah, tell us something we don't already know. And, here's the judge sitting there going, but that doesn't justify what you did to this guy, right? And all we asked him to do was, we want this in an Article 3 proceeding. Guess what happened? It went to an Article 3 proceeding. It took almost a, better part of a year for that to happen, but it did happen. And along the way, we've knocked out a couple of bad actors that were literally caught. And because we have agreed to kind of, leave those actors, for lack of a better expression, to the investigators, they've said, hey, because we can respect the investigative process, and we're pretty good at that, they're doing it. And that's what we're saying. All we wanted you to do was do it. As far as the law is concerned, this has got nothing to do with the law and everything to do with the way you guys are practicing it. And again, that's when the whole guidance documents thing came out. In other words, yeah, your policies, rules, and procedures that manage government, dude, that ain't got nothing to do with us. So somebody sent me a case today. I forget who it was. The Supreme Court just came out and said that corporations do not have jurisdiction over the natural man. Again, tell us something we don't know. So in other words, even the Supreme Court is seeing these things and they're picking it apart piece by piece because they know that's exactly what we're doing. We're like, we're not going to be able to go in there and just wipe it clean once and for all. We're going to have to pull out certain, it's like playing Jenga, right? You got this block and you pull out certain pieces. And as long as you only pull out certain pieces, the whole thing doesn't collapse. So we're just pulling out enough pieces that we're going to deconstruct it from the top down. And you know what? As long as we're doing it and we're doing it the way the court tells us to do it, and we're working with them, they're like, yeah, you know what? You're right. We get it. We understand. We know there's bad actors who did this, and give us some time, work with us. And that's exactly what we're doing. So, that's one of the reasons why I'm so damn busy. Kirk's busy. I know John's busy. We don't have time to get on here very much. And I know I've heard rumors about everything going on, and I don't care. I don't care. So you got always somebody trying to say, hey, you can't do this, or, hey, you're taking this and making money with it. Well, good. Show me the transactions. Because you can't show me the transactions, just go play. So there's my remarks on that horse shit. And
to read some comments?
Yeah, go ahead, Ted. I was just going to try to catch up a little bit.
All right. So since I'm here, and this is back, let's say about 10 minutes from Valerie A. Stewart. This was the first question I saw because there's a question mark. I can transition me into the show. Valerie A. Stewart asks, and you guys will have to kind of remember back 10 minutes or so, 10, 15 minutes. Did
Sure.
they have a waiver? Question mark. They must have a waiver, and they never do. Foreign sovereign immunity is like China suing the U.S. You have to get permission. You have to get the immunity waived.
And that's actually fictitious. That's in the rules, but that's not in law. And that's one of the problems, that one of the disconnects that that I know I've found in my reporting. And it's like, look, we're not asking you for a liability situation. We know that's what the other guys are trying to persuade you, that everything is going to be a liability and there's going to be all this money and blah, blah, blah. No. Okay. What we're saying is, here's what the law says, the contract thing, that Constitution, right? Every time you guys do pass one of these statutes or one of these bills of attainder, or, allow these bad policies to go into effect, right? All of this crap is repugnant to our form of government. It attacks the integrity of the court, the integrity of the Congress, and, the integrity of the law. And they've gotten so bold about it that they have even come out and said, in one of my cases, this idiot judge actually had the nerve to say, we don't follow the law in this room, we follow the rules. Wait a minute.
Now
how do you justify, you're going to call this a court of law, right? But now you're going to have the nerve to sit there on the bench and say, we're not paying attention to the law, which is kind of a reach up and a bitch slap to Congress, right? Guess what happens when we told the committee, the Judicial Committee, that that's exactly what happened in that case? Because had we not done the reporting, there's no way they would have ever known it. And that's where my company comes in, because I provide that third party, uninterested, right? That check and balance. Here's the reporting. Here's what happened. Here's the reporting on it. Now do you see what we're talking about? And the Judicial Committee in that state is pissed. They are pissed. And you know what? They should be. So to say that, this is going to happen overnight, or this one's doing something that's better than this one. Hey, guess what? Took them 230 years to build it. It ain't going to take us 230 years to deconstruct it, but it's not going to happen overnight either. So,
yeah. I want to comment on Valerie's question. So you have to get permission. You have to get the immunity waived. False. You don't.
Right.
And the Supreme Court has said that the 11th Amendment sovereign immunity is necessarily limited by 14th Amendment protections. That's the whole purpose of our federal government, was to secure the things of liberty and the pursuit of happiness. That's why we have a federal government, because the founders recognized that the states would not be responsible always, and that the people had to have some means of redress. Now, Chris made the statement that what they're doing is a bitch slap to Congress, and he's absolutely right. Congress tried to protect us again in the 70s and 80s when they enacted parts of 42 USC, and particularly Section 1983. Congress tried to give us protection. Congress stated during that, judges or sheriffs having eyes to see, see not. Judges having ears to hear, hear not. And because these guys have been screwing it up for so long, we're going to have to provide for them what they can't provide for themselves, which is a fair hearing and fair due process. And right. That's why they enacted 42 USC Section 1983. One of the other legislators that was advocating for 1983. I lost my train of thought with that guy. Let me come back to that. But another piece that I'm working on, and that I'm asking the Supreme Court, I asked the Sixth Circuit, and the Sixth Circuit refused to answer the question. I asked them very directly, when a state is no longer Republican in character, does it vitiate its sovereign immunity? So going back to it was Valerie, Veronica, going back to her question, Valerie, they have to waive immunity? Bullcrap. They have vitiated their immunity because they're no longer Republican in character or form. Now, the Sixth Circuit was unwilling to answer that question. They just...
Have you read Tolman versus Finneran yet?
What?
Have you read Tolman versus Finneran yet? From 2001?
Nah, I'm not familiar with that one.
Because basically the short version of that was the 11th Amendment does not protect the state officials from claims for prospective relief when it is alleged state officials acted in violation of federal law, right?
Of course, but the federal district courts and clearly the Sixth Circuit, they're not interested in what the Supreme Court has to say. I don't think. They don't seem to be.
There it is right there. And there's your answer. So when I filed my reporting and said, look, the Supreme Court says this, here's what they're doing, okay? In other words, you've got an encroachment. You've got a clear trespass. Here's the trespass. Here's the proof of that trespass. It's already in the official record. It's not like you can dispute this. And basically my reporting and my activity through Congress is they're like, well, yeah, duh. Well, then why is the court saying what they're saying? And the answer is because, well, there's so many of these cases now because of all of this constructive fraud. So if you're paying attention to the big picture, and last week sometime, Sean Hannity did an interview with Devin Nunes.
With who?
Did you see that interview?
No, with who?
Sean Hannity did that interview with Devin Nunes.
No.
Where Devin Nunes was talking about trying to get to the bottom of the abuses of the FISA court, right? They're talking about that Russia crap. And Devin Nunes clearly said he's waiting for the Inspector General's report so they can decide whether they're going to, if they're going to proceed to contempt or impeachment. But basically, the short version, the preliminary reporting, clearly demonstrates where the Justice Department weaponized the FISA court. Where do you think you got that language? So, to say that working with these people is a bad idea, that's the wrong answer, because we're providing answers to questions that have been obscured, right? Hence, when they start giving us gag orders, when they start trying to selectively include and exclude evidence, all of that crap. Okay? Like I said, take copies of it and, make a freaking report of it. And again, as far as the argument goes, Congress clearly understands what my practice is in loss prevention. So they know damn well there's no jurisdiction to do what they're doing. The Supreme Court just affirmed it. Corporation does not have jurisdiction over the natural man. So guess what that does to everything? You got to hear people screaming about the birth certificate, and all of this constructive fraud. That just took everything and threw it in the toilet. So, again, we no longer have to have that argument. Now what we have to do is go in and clear the record. Well, Congress said, where do we start? I'm giving them clear-cut examples of where you start and clean out these records. Because once these records go away, that branding, right? Remember we talked about that? That also goes away. Guess what happens to public trust and consumer confidence? Both of those things start to go up. And as those things go up, you can watch the stock market rise, right? So we can clearly show that there's a definite commonality between public trust and consumer confidence. Those two things are equal. And,
so are you
so you can watch. What's that?
Are you telling us that the corruption in the lower courts is in some way connected to the Great Recession of 2008?
That's exactly what I'm telling you. And here's the reason for that. Okay? Again, something being sold under the color of good faith, right? What was it? Bush did that. We're trying to, we wanted that, they're trying to use the Housing and Urban Development, HUD, to help poor people, buy housing. So they created all of these, what's called subprime lending, right? They gave loans to people who couldn't afford to make the payment, right? So now we've got all this real estate involved in all of these subprime loans that were junk to begin with. Now we folded these suckers up into securities. They're trading on the secondary market like stocks are. And because they're trading by people in authority under the color of law, guess what that is? Okay? Those are also emoluments, right? That's part of the entitlement mechanism where they're trading all of this crap and selling it to China, and then this part's going over here and that part's going over there. But because it was all based in fraud, guess who's going to end up owing that money back? The people who wrote the legislation. Oh, no, not us. I mean, when you're talking about, there's a, John, help me out here. When you go and you infuse a bunch of money into the economy, what's the name of that? Can't remember it off the top of my head. Shit. It was a common practice back in the 80s and 90s. they would infuse a bunch of money into the economy.
Oh, well, you just said it. That's what they do. They just infuse.
Yeah, but there's a
bunch of
name
money.
for it, and I cannot remember the name for it off the top of my head.
There is a name for it.
I want to jump on a comment here, Chris. This one astounds me. So that Trisha, I don't know if I said her name right. Trisha Ferguson. Supreme Court in Indiana just told me I have to ask permission to go pro se from family court. What the hell is that? So that's nothing but a monopoly and forcing you to pay money.
Right.
That's like, wow.
Yeah, and that's what they're trying to do. And they've been getting away with it.
Yeah.
Right?
Nobody questions them. And they don't have to worry because most people don't question them. And,
right.
then if they do question them, the district courts aren't going to enforce the law.
Right.
The district courts apparently are not going to enforce the law either.
Right.
It's like, what do you, but we have to keep raising our voices. We have to keep evidencing in the record what is going on and take our cases as far as we can, and object to everything that comes out, go to every higher court that we can go to, and try to get the Supreme Court to hear our cases, because obviously the district and the circuit courts, from my experience.
Teresa has a few more comments. She was taught by the military not to answer any questions that she felt uncomfortable with. So she's a little bit ahead of the game here. She also goes on to say the Supreme Court in Indiana just told me I have to ask. Oh, that's what you just said. I have to go pro se from family court. It's a big stupid circle.
Yeah, there's another one. I just got from Amanda. I just got notice to hire a lawyer or have my objection delayed. They're just forcing us to pay these attorneys to force us and subject us to vexatious litigation. It's just nuts what's going on in these courts right now. They got free reign, man, because the federal courts won't do anything. I think it's going to get really, really, really ugly with these guys if the federal courts don't get their act together and start doing something about this mess. Look at California right now, the homeless problem out there. The government is just coming up with ridiculous laws to extort business, to deprive people of their rights in California. Look at Venezuela and what has happened in that country because of corruption. And that's what's going to happen to this entire country if these guys don't get their act together. It's going to keep dragging the country down, forcing more people into bankruptcy, forcing more people into homelessness. If they don't stop this, the substance abuse, the suicides, everything that's going on out there is all tied back to the corruption in the state courts and the federal courts' unwillingness to do anything about it.
Well, and again, yeah, I can hear you, Ted. What's up? Thank you, Alan. Quantitative easing. I was trying to. Alan's here, and Alan got my back. Love you, brother. Well, I'm going to finish answering your question, Ted, where we were talking about the real estate market. Okay. So when they took these real estate securities and they bundled them up and they threw them into that secondary market, well, that's where all the money went. So they had to add more money through quantitative easing. Okay. And here's the problem with quantitative easing. It's like the game of Monopoly, right? When you get to the point where all the properties on the board are mortgaged, right? And nobody can do anything because everything is mortgaged. So typically the person with the most money will redistribute some of that money to unmortgage, okay, some of those properties to allow the game to continue, right? Well, at the end of the game, when the game is actually over, the game is over. But in real life, with quantitative easing, when the game is over, you actually owe the money back, right? And that's kind of the problem of where we've gotten with this quantitative easing and all this constructive fraud. So that, thank you for jumping in on that, Alan, because I could not remember quantitative easing to save my butt. It's been a long week, man. But that just kind of give you the idea. Maybe I had to use little boys or something. Right. There we go. I'm back.
And there is white noise. So, yeah, nobody can hear me without the white noise. So I'm going to, I'm just going to let you guys do your thing, and so I don't annoy people with the white noise.
Gotcha.
I gotta figure this out. Yeah, now I can hear it. It's coming in here. I'm just going to turn my volume off. I'll figure this out in the morning.
Gotcha.
My sound's good tonight, yeah?
Yeah. Yeah, the Laura's right. That's where all the money went, right? It's all in the offshore accounts. So she would be correct. That's one of the reasons why we're trying to get those funds repatriated, which is one of the things that Trump's trying to do. And because kind of the long and the short of it is we've reached a plateau. It's like, look, either the people are going to revolt, okay, which is what we already know is going to happen. We saw what the electoral numbers look like. So if we end up in revolt, that's not going to go well. Let's just put it that way. It'll be over before it starts. And that's a good thing. So, when there's fear in government, that means we have liberty. So we're starting to see that actually starting to become reality to them. They're like, these people are pissed, right? They put up with this crap long enough. When they're starting to come at us with the Declaration of Independence, for example, that's it. It's game over, right? And the problem with it is how do they deconstruct it politically? Because it was constructed politically. How do they deconstruct it politically without a bunch of smear campaigns, right? Which I would imagine is kind of their first, their first test cases as to how people are going to react. So when you see, what was it, 3 or 4 days ago when CNN and all of the liberal media was every other word out of their mouths was that porn star's name. The more they do that, the more people just tune them out. So even they realize that
I want to jump on that.
It doesn't even matter. People aren't even listening anymore. They're tone deaf.
I want to jump in on that, and Chris, you're absolutely right. We have hit a tipping point with this thing, and it's going to go one way or the other, and like, well, how do you address this problem? This big, huge, freaking problem with Title IV incentives, with vexatious litigation, so lawyers can get paid more money. How do we deal with this? And this is Chris. You know, I'm working hard on reform in Tennessee, right?
I sure do.
And man, I want simple stuff that's easy to implement, doesn't require any legislation, doesn't require any bad actors to go away. It's like this is stupid simple. The systems are already in place, and here's how I suggest that we fix this problem. Is it's so stupid simple when you hear it. Returning power to the people in the form of juries. That fixes 90% of the problems. You know, some of the crooked lawyers are really good salesmen, and they can sway a jury. But not all the time. If they don't have evidence and proof, you know, no matter how good a salesperson they are, you know, they're not going to swing a jury to rule against justice. And so that's the number one reform that I want. Our federal constitution says in any matter exceeding $20, which is $600 in today's money, I think, that we have a right to a trial by jury. Our state constitutions, most of them say that we have a right to a trial by jury in any matter where there's property or liberty involved, which is, you know, a lot of the family court cases, child cases. You know, there's rights and property involved in that, and so we should have juries. So the simplest thing that I think is if you get in there and you got a judge that's colluding with an attorney, and you're not being provided due process, you just say, time out, guys. I want to stop this thing right now. And I want to assemble a jury to hear this matter. Chris, would that not fix 90% of the problems if that happened?
Oh, I would say probably 98% of the problem, because here's one of the things that juries decide. The juries decide, you know, like grand juries, for example, is there standing in law to even pursue such an action? So when we talk about cases like the baker, right? That baker that got sued for not baking that cake for that gay wedding or whatever it was. Had that gone before a grand jury would have said, look, there's no standing in law. That's a freedom of speech, you know, religious practice right? And we can well document that. And that sucker would have been over. It would have been over before it started. But because of all of this constructive fraud, and basically the lawyers are saying, well, yeah, of course it's legal. If you don't believe us, ask us. Oh, God. You know, even the court's going, you know what? No, man. No, you're not. And it's a, you know, they know and they understand the political corruption. They know and they understand the circumstances of, you know, if Congressman so-and-so doesn't sign off on this bill, you know, Congressman so-and-so's rat squad is going to go blast that poor bastard all over CNN with some kind of sick, you know, smear campaign. Hey, guess what? They've been doing that shit to us for how long? Do you think we care? Even if you did get a Hummer in your office, dude.
Yeah.
Nobody cares. Right? So, you know, let them smear away. We'll have a beer over it. I mean, you know, because, you know, think about it this way. Sam Clemens, Mark Twain said something years ago. If you if you don't read the newspaper, you're uninformed. If you do read the newspaper, you're misinformed. And people still know that.
Yeah.
So
I want to, I mean, Brenda said it well. Brenda Johnson, she said, we have to provide the corrupted system with a comfortable solution to their own corruption without incriminating them, then they will change. And that's what I think I'm proposing, to say, if you feel that your rights are being violated and you're not being provided a fair trial, you just say, whatever it is, traffic court, child custody case, divorce, whatever, timeout, I want a jury. Now, the only reason that the legal profession and the judiciary would not want that is for the single purpose of violating our rights. That's the only reason they would not want that they would want to retain that power and to deny us the juries that are guaranteed in our federal state constitutions. That is the only reason that they would not want that. If they're providing a fair trial, there should be no need for us to want a jury. So the fact that they don't want to give us that means that it is their design, it is their intent to deny us due process and to violate our rights. So that's the number one reform that I want, is that when bad things are happening in the courtroom, our children are being taken, our rights are being deprived, that we say, stop, I want a jury. That's number one.
Right.
Number two is that there is no oversight of the judiciary, and we file a complaint, whether it's a federal judge or a state court judge, those complaints are dismissed. We have to return power back to the people in that regard also, in the form of juries, and say, okay, fine, you dismiss my complaint. You're obviously buddy or part of their fraternal organization, and you don't want to enforce the rules and the canons and the codes of conduct. Fine, let's see if a jury will. And I think by that happening, these judicial oversight agencies will start doing their job, because they'll be embarrassed when a jury comes in and overturns their dismissal. I think that solves a lot of the problems. And the final solution is the states must be ordered to stop asserting sovereign immunity when we are trying to enforce a right of due process and a right of equal protection of the laws.
Right.
When we go to federal court and we sue bad actors, they should be ordered, the states should be ordered by the Supreme Court to say, you idiots, we have said it 20 times in 20 cases that sovereignty does not supersede 14th Amendment protections.
Correct.
Those three things happened, it would change this country overnight, I believe.
Yeah. So when we talk about
the only reason you don't want those things is so you can violate our rights, take our property, and take our children. That's the only reason you would not want those three things. And that is prima facie evidence of the state fighting me.
Right.
Prima facie evidence that is their intent.
Right.
Is to perpetrate crimes, violate rights, and deny us our protections that are guaranteed in the Constitution.
Correct. And that's one of the things that I've actually clearly established in my practice is I said, look, based on these situations, here they are. Okay. We did not have equal protections under the law. I mean, it is what it is. And the only way we do that is we have to be able to have an adequate defense mechanism, because everything being handled by prosecutors ain't the answer, right? We're right back to that system that we declared independence from. So how do we do that? And my answer was, we need to finish this thing that was started right before the War of 1812. And Congress said, you know what? You're not wrong. We need some kind of a defense mechanism and a way to know and understand how the hell we're going to manage this judicial thing, because it's gotten way out of hand. It's become tyrannical again. You guys nailed it. So I came up with some legislation, and I wrote it and submitted it. It was the practice equalization bill, and it's before both committees right now, both Senate and House, and they're reviewing it. And what it does is it takes the no-fault divorce. We kill that, and we replace that with brokerage firms. And that's something that works well because that's something that could be managed through errors and omissions insurance. It can also be managed through proper reporting, required reporting when we, you know, when we work a deal or when we broker a deal, that information gets uploaded into the court of record, right? Well, Congress, that's point and click oversight. They could decide, hey, I want to look at cases in Florida in income bracket so-and-so to so-and-so. And when they pull that up, all of that data is going to be right there. And they can narrow their searches down and it will be true and correct, accurate reporting. Like you said, John, I mean, there's, truth in the record is critical when you're talking about transactions, occurrences, or events, when you're talking about money transactions, equity transactions. So again, because nobody's ever done this from, hey, we already know what works. It ain't broke. It ain't broke. Don't fix it. We've been using it for years. Let's do that. And they're like, okay, well, we got this other problem. We got these 230 years worth of monopoly, and they're throwing terms at us that sound like they belong in a Starbucks. Dude, we don't care. We don't have to ask the court if we can lie. We pretty much got that one, So, we got this, right? We can govern ourselves. We don't need the bar to govern us. Get the hell out of here. And that's pretty much what we're doing, is we're at the point now in Congress where you got these bar lobbyists and these bar members. Well, we're going to this and we're going to that. No, you're not. We're going to boot your ass right out that door. And we're going to do this our way. Wait, why? Oh, guess what? That's what the law says. Go ahead, dude. Yeah. So basically, when we talk about the issue of juries in family court, we don't need juries in family court. What was family court designed to do? Family court was designed to dissolve the marriage, right? And dissolving the marriage is a division of debts and assets, right? The Supreme Court has said in multiple cases, pick one, that parents have a liberty interest in their children. Guess what? They have said that so many times that they don't want to hear the question anymore. They're like, we've already said this, go. We're like, cool. We know what you're saying. You're going to have to go to Congress and you're going to have to deal with this no-fault divorce thing. It is what it is. And that's exactly what I've been doing, is I'm going there and I'm saying, hey, look, what this thing that was presented under guise of good faith ain't working, because it's now perverted into a weapon. The Supreme Court has said you can't do what you're doing, so quit doing it. And we've narrowed it down into this thing called admiralty jurisdiction. They're literally stuck. They can't waive or salute. That's why there's no enforcement of anything. So they know as soon as they try to enforce something on us, we've got equal representation. We're going to hit them with all 9 guns of hell. And I mean, the difference between admiralty law and common law, admiralty law is not shit when it comes to the comparison between that and common law. Common law will rip you to shreds and like drawn and quartered and public hangings. And, it's like, oh God, I didn't want to think about that. But
certainly there's jurisdictional issues with these admiralty courts. You know,
Well,
certainly there's issues with the legislation about no fault divorce.
Mhm.
But we need a way to dissolve relationships. We need a way to, well, I don't know that we need a way to design to set up custody. I mean, it seems
Right.
obvious to me it should just be equal, period.
Well,
But
and that's what the law says.
but we need a process to divide up the assets. And so what I'm suggesting is a stopgap solution until we get something else in place that we have a right to call in a jury. And I think it's a good temporary solution until they unscrew everything else.
Right. And here's the thing about that. Every state already has a standardized form when it comes to how you enter the initial interrogatories, right? What's the debts? What's the assets? You know, you need the account numbers, who owns what, you know, how many pieces of property, how many cars, how many boats, how many jet skis, I mean, whatever. And, you know, if it's stuff that was obtained before the divorce, well, guess what? That was this guy's, or that was her, that was his or hers before the divorce. It's his or hers after the divorce. Everything after the time before they separated, that's also his and hers. The only stuff we're talking about is what's right there in the middle. The time from the time they got married to the time of the separation. That's the stuff that we have to divide. And there's already an equal, there's already guidelines. Every state has them. Yeah. And that's definitely speaking the third way. Or you can enter into the contract reasonably. And for example, I saw a YouTube video. This guy was ordered to give half of everything. He cut his house in half. He cut his truck in half. He cut his cell phone in half. He cut everything in half. All of it. It was the funniest damn thing I ever saw. So
it should be like TurboTax, man.
Yeah.
You go through it, ask the questions, and it spits out an answer. It should be as simple. Divorce should be as simple as TurboTax with expert software.
Right.
Yeah.
Right.
Yeah. Well, of course, we don't want to do something simple like that because the lawyers want to get paid.
Right. Zach just said it very right there. No, children are not property. I don't care what any law says about that. Definition needs to change. And he's exactly right. The law says you cannot deprive somebody of their life, their liberty, or their property. That includes their family, especially their offspring and their children. So if all you have is an allegation of domestic violence, but you got no proof of it, you're going to have to prove your case. Period. End of discussion. So as far as I'm concerned, I don't care if it's male, female, whatever the hell. Pick there's how many different genders now? That cracks me the hell up. Doesn't matter. That child has a mom, that child has a dad, and anybody else who wants to dispute that, I'm sorry, that's the way God created us. Deal with it. But anyway, the kid has a mother, the kid has a father, and that's just the way life is. Kids are going to end up where kids end up. Guess what? That's just the way of things. So, 1 year they may decide, hey, I want to go to school from mom's house. Okay, cool, no problem. I want to go to school from dad's house the next year. Hey, no problem. As long as they're going to school and they're getting what they need, who gives a shit where they live? What we don't have, what the state doesn't have the right to do, is to adorn that time and say, we're gonna sell that time, and we're gonna extort money from you, and we're gonna call it legal. No, you're not. And that's basically what I've said in my argument. And it's to the point now Congress is even saying, you know what? The court hasn't come right out and said it quite that way, but what they have said has been pretty direct. So, in other words, we're going to have to take this damn no-fault divorce and we're going to have to do away with it. So, show us something that we can replace it with. I gave them an answer. I didn't just go in there bitching about a problem. I went in there with a comprehensive answer. So what if it pissed off the attorneys? I don't care. Guess what? If it comes to pissing somebody off, hey, I'm good at that one. I'll take that. I'll take credit for that. I don't care. But what you're not going to do is you're not going to use this crap against good parents. And that's exactly what's happening.
The thing that astounds me, that I have a hard time understanding, is how can attorneys in good conscience victimize parents and feel good about it or sleep well at night? When
they get paid, they pull that justice bone out of their head in practice in law school.
There's no amount of money you could pay me to go bully my fellow man.
Me either. Nope. That's why when it was asked, how much do I want for doing this? I said, I don't want your goddamn blood money. Keep it.
It astounds me that these guys continue this practice day after day, suborning perjury, coming up with ridiculous bullshit arguments.
Yep. It's
litigation and basically to extort families and take all their property. How the hell do they do that in good conscience? And how the hell do our federal courts continue to allow this to happen in good conscience? It's just
an evolutionary process, right?
Yeah.
It just astounds that money means so much to them that they can sleep well at night knowing that their failure to take jurisdiction or of the bad actors is causing somebody to engage in substance abuse, commit suicide, taking the lives from the children because the family has no money to pay for their college, to pay for their well-being. It's like, God, you guys just suck,
Right. Well, here's the best part. You've got professional people, and there's many professional people out there. I don't want to take too much credit because I don't deserve it.
Check.
And there's a whole lot of good people doing a whole lot of good things. And, I've encouraged those people to use me. If you want to throw me to the wolves, go ahead. I got a big ass. They'll have trouble taking a bite out of mine. I can tell you that right now. And I don't care. So, because as far as who has jurisdiction to prosecute me, nobody. So, as far as that's concerned, we've agreed to disagree. As far as the argument, the emoluments argument is concerned, that was me just reducing admiralty jurisdiction to a math equation. And like I said, I don't care if it pissed him off. I wanted it to piss him off because guess what? Until somebody gets pissed, ain't nothing going to change. So I just took and threw a monkey wrench right into that program and said, now, what are you going to do about that? Because ain't nothing works. So that's what we're doing now. We're fixing it. So, again, you can believe the hearsay if you want, but that's kind of one of the problems that we have in this situation is every one of us has suffered from hearsay at one point or another. So, that's like I said, that's one of the reasons I post everything that I do. I create the sword. If you guys want to learn how to use it and put it in my hand and say, here, drop it in your case, go right ahead. Those reports are published for you guys. I've already used them in my particular case, and it does what it's supposed to do. Shuts down their shit show because it completely demonstrates there's no jurisdiction to do anything, especially under admiralty law.
I'm gonna drop a plug on that note. So we have, I'm looking at Kirk's Law Corner Live. There's 29, 30 people on there.
Mm-hmm.
So you 29 people hang with me for 1 minute. Chris, Kirk, other people from across the country are coming together to demand reform through a petition for extraordinary writ and mandamus in the United States Supreme Court. We're going straight to the top because the district courts and the circuit courts won't hear us. So for you 29 people out there, let me know that you guys want to join this. No work you have to do. The only thing you have to do is give us your name. And we're going to take your name and say, this person, wherever you're from, wants reform of their state. The state has enacted unconstitutional laws. The state provides no means for us to address grievances. We want reform, and we want it now. And we want the Supreme Court to order the states to give us juries to get rid of these unconstitutional laws. So I would challenge you or beg the viewers out there. There's 33 people on there. Tell me that you're with us and that you want to join this action demanding reform. I would be grateful if people would write some comments on there and let us know that you're with us. Nothing to do. We're just going to be filing into the Supreme Court saying we want juries. We want to be able to take it to a jury when a complaint is dismissed against a judge, and we want to be able to enforce our right of due process. And I'm sad I don't see a single person saying, yes, we're with you.
It takes a minute. It takes a minute to come up on the...
So we're working hard on this case. We're working hard on finding people around the country. I expect when we bring this case to the United States Supreme Court that we're going to have 500,000 people or better that are on this case. And we're going to go back through the comments, and the people that mention yes on here, we'll contact you and we'll let you know when we file this thing. We'll let you review it before you file it and say, give us a final yes to say, I want my name on this in the United States Supreme Court. So I beg you guys to join us and stand up just by giving us your name.
Just think of it as signing a petition, because this is not us going in and asking them. Remember, as our practices are constructed, mine is a practice as a friend of the court. I have claimed my space in the State Department, which is to perform that fiduciary duty that Congress wrote, right? I said, okay, no problem. I can do that. And I'm going to start giving you all the reporting. So as we're constructing the arguments in the court, I'm also going to be providing an additional reporting to Congress. So literally Congress can watch this in real time. And we know and understand that they can see that through the, through Pacer or Westlaw or, the various other electronic versions. But to get a reporting in real time from our side of the litigation table, that's going to put it into a whole different kind of perspective, because we're literally showing them that, look, the people have come to us and they've asked us, they have also by signature, which is the same as a petition. We have the right to petition the government. So we're petitioning not just the court, we're calling a meeting between all the branches. And here's where we're going to show what we believe to be the problem. And, do you guys how do you want to handle this? Does the Supreme Court want to act as the mediator? Does Congress want to act as the mediator? Do you want me to act as the mediator? I really don't care. But we're going to need to go down through this sucker and figure out what's constitutional, what's not constitutional, and get rid of all of that crap that's not constitutional, that, like John says, vitiates our form of government. And ultimately speaking, I think that's something that the court would endorse. I think they would reluctantly endorse it, but I think they would endorse it.
Yeah. So
only because it is what it is.
So basically, we're just asking. This is very similar to a class action lawsuit. We'll all be complaining on this day, demanding reform based on our state constitutions. Most of them say we have a right to reform the government. And
there's a real bad hissing noise, John.
Huh?
Is that you, Ted?
It's gone.
I got a real bad hissing noise here.
Yeah, you get that.
Yeah.
I don't. When I turn off.
Are you guys still hearing that? I've got myself on mute on one end, and I've got like a compressor on my mic, so you guys will only hear the white noise while I'm talking.
It just stopped. It just stopped.
Just stopped. Well, let me ask you this: no matter what we do, John, and I hope people can hear me with the white noise. It's going in and out as I speak. I can't mess with the mic right now, otherwise I'll shut all the audio down. But the ultimate goal in my mind, as everybody knows if they've listened to me for the last year on different shows and stuff, we can't get married by just a license. We could when there was action for divorce. And we still can, even under no-fault divorce, if there is an action for divorce. But if there is no action, and one or the other person just wants a divorce for no reason, then there won't be a winner and a loser. There'll just be 3 losers if there's only one child. If there's 2 children, there's 4 losers. So that's why there needs to be an exit strategy. Whether there's children involved when the 2 people get married, if there is not an exit strategy, just like in any other business contract, then there will be attorneys taking advantage of it. So, sorry Las Vegas, sorry Atlantic City, but I don't believe 2 people should be getting married under no-fault divorce, or in any way this day and age, without having an actual civil contract, a private civil contract with an exit strategy. And I'll tell you what, when I married my wife, or whenever I started a relationship with any woman, if I thought I was going to marry that person and spend the rest of my life with them, I would tell them, and this is me, you know, you can say what you want about me, but I'm a nice guy. I try to do what's right. And I believe that if I had to sign these things and have an exit strategy, and if I said, okay, any future residence, any future household we may own, I would like you to occupy that with the children so they have an anchor in their life. That might not be every guy, but I believe for a lot of guys, that's the way they would go. It's kind of a natural way.
Right.
In doing so, in figuring things out like that, you may think like, oh no, that's half that house is mine. Really, I don't care. I've lost so much money over my life, over the time of my life, doing so much for other people, that I'm used to losing money. But what I don't want to lose is time with my son. So you know what? You can keep the house, you can keep everything. All I need is my car and my time with my son, equal time, however that works out. You know, you can also say in the contract that I have to stay within the jurisdiction, the school jurisdiction, not the court, but you know what I'm saying. I have to live within. Right now I'm screwed. I live 1,500 miles away from my son, so it's not like we're going to have equal time sharing anymore. But at the onset of this, I was a little over 35 minutes away. There was really no reason why we couldn't have equal time sharing
Agreed.
in the same school jurisdiction.
Right.
As long as you're within a reasonable different distance,
Right.
under an hour, then equal time sharing should be automatic. 1
Right.
week on, 1 week off is the usual. You know, some people have some very creative ways to deal with this, where the mom will stay in the house 1 week, and then the dad will stay in the house 1 week. That's very creative, and you know, I applaud the people who can do that. But
Right.
my wife's house is my wife's house, ex-wife. You know,
Thank you.
she's not going to be leaving ever.
Right.
But you know, I want to address that just really quickly. This
Sure.
is not my fight is not about just
I know.
family
You
court.
might want to mute your mic there, Ted,
I
because
want
we
due
can
process.
hear it.
I mean, this affects so many more things than child custody and family cases.
But
So
I
much
think
more, so much more is affected out there. And so, you know, my fight and the fight that I want people to join us out there is about getting due process back.
well, that's just it, John. And the
And I, you
the
know,
way
I mean,
that lower courts have changed everything, given themselves a niche market. I mean, it's been an evolutionary process, but everything that is wrong with our country stems from the lower courts. We can all agree on that. It's the lower
Yeah.
courts creating their own legislation bypassing the legislative process. So
Well, no, they create their own rules and bypass the legislative process. So-
exactly, their own legislation. They create their own everything. And it goes beyond family court, but family court is the center of it. There is no other court system that creates their own rules like family court does.
Correct.
yeah, so they could exploit the ignorance of people who don't know the law.
Yeah.
Right.
Just, you know,
Well, you don't even have to go to law to go to family court. The family court is not about law. The family court is about their rules, right?
Right.
Their policies, their procedures, their rules. The law doesn't have jack shit to do with it.
Right. So this
That's
is
the problem.
my fix to, like what Zach Hoffer said. And people who say that mediation doesn't work. Yeah, mediation doesn't work now. Mediation doesn't work because we have no contract. In this situation, nothing works. We're
Right.
all effed up the A, no
Yep.
matter what we do.
the only winners
So-
are the attorneys.
Exactly. And
And-
that's exactly why no-fault divorce was created the way it was. And just 4 years later, CPS was created, basically.
Yep.
Or the current CPS as we know it now was created. So
Yep.
if you take things, you know, you need A to complete B, to complete C, to complete D. This is why all of it is symbiotic. You can't get rid of CPS and still have a family court system. If you allow one group of people to have jurisdiction over families, then everybody has jurisdiction over families. So if we tell the lower courts, we tell them, look, you're done. You have no jurisdiction here. This is a private civil contract. You guys have been doing your thing since technically 69, but it didn't take effect until 1970 when Reagan signed it into law. And like everybody says, that was the biggest mistake he ever made in his political career, according to Reagan. I hope everybody can hear me okay with a white noise, because I just turned on my mic and I can hear the white noise too.
Right.
And I don't know what I did to my jacks. It's not USB. I'm connected directly in. I think I have simply a wire problem, which really sucks. But anyways, if we, the easiest way to remove jurisdiction from an illegal court system is to privatize the contract. Right now, we only have a license. So, all right, from now on, or we could even go from this date to whenever in the future, you need to have a private civil contract in order to get married.
I get a better idea. Keep government out of it.
Well, that's why there's a private civil contract. How else do you keep them out of
it? Well, and that's just it. They've got no standing to get involved in it to begin with.
No.
The relationship, the human condition, okay? You cannot legislate the human condition. Period. End of discussion. It's been tried before.
Here's a good point on that, Ted. Leslie Bauer made the comment. Prenuptial agreements are only for premarital assets, and they don't even hold up. And so even if you have an exit agreement, exit strategy like you're talking about, they're still going to find a way.
I know what you're saying. I understand what you're saying, John, and this is.
That up.
I'm sorry to interrupt you, but the problem is the jurisdiction right now is family court. If you have listen, if I build you a house, we have a private civil contract with an exit strategy. If I'm building you a house, there's no way that our contract is going to end up in family court, correct?
The difference between that, Ted, is the contract you're talking about and the contract of a union between a man and a woman, for example. Your contract has a beginning and an end.
That's what I'm saying. We need a beginning and an end.
Well, then the vow says, till death do us part. So
that's again, not what we're dealing with anymore.
I get that. So basically, kind of the long and the short of it is, the only way that the court can get involved is if there is an action committed by one or both of the parties where it warrants some type of law enforcement or court involvement. So allegations of abuse, for example, that doesn't warrant it.
No, you're
because they have to prove that's Article 3 proceeding.
Anything criminal, when it comes to, this is why there was no real family court before no-fault divorce.
Right. That's why I said that shit's got to go.
Right.
You can't even get a case number until you can prove, unless you can at least show that there was an actual event that happened.
The problem is now, whether there's an action for divorce or not, it all gets seen in family court. They have no jurisdiction over criminal matters.
Right.
I mean, if we're going to keep no-fault divorce, then every divorce should go in front of a criminal judge at least.
Well, and that's the argument. And the court has said, hey, look, we don't want to hear issues of divorce.
Right.
Right.
So there should two people
my
going
question
in front
is,
of a judge.
If the court doesn't want to hear it, then why the hell are we doing it? Right. Because guess what? I don't want to bother the judges any more than they want to bother me. It's that simple.
And that's why, if we're going to keep, we can do one of two things. We could go back to action for divorce, and once you get married, you can never get a divorce. Or keep the constitutionality of no fault, but understand that the process is unconstitutional, and create a private civil contract for each marriage. I'm going to shut up. Yeah. Kirk is back with us. I'm probably going to ask you guys to turn off your cameras real quick so I can put Kirk in the number one camera spot. So just bear with me.
Okay.
Mr. Pendergrass. Are you back?
There he is.
Oh, but you're still on your phone. Uh-oh.
Can you hear me?
I can hear you. We see see you.
Talk again.
Happy reception.
Yeah, you got bad reception. I can hear you though, bro.
Okay. All right. So this is the thing we need to understand about marriage. Again, this is one of those natural rights. Marriage, marital rights, and parental rights have nothing to do with the establishment, support, or management of the government. That's actually in American jurisprudence, volume 15. That's under civil rights section, section 2. So understanding what marriage is it is a religious act, a sacred vow. So marriage has been misconstrued and converted. Attach a fee to it. That Murdoch versus Pennsylvania says can't do that. Why? It has nothing to do with the establishment management of the government. Convert your right into license, attach a fee to it, and subject people to.
Ted, turn off that mic. We can't hear Kirk, bro.
Yeah.
Let me see if my audio will make it stop doing it.
Let's we're pushing about 9 o'clock now anyway.
Yeah.
We've got some technical issues going on.
Yeah. Well, basically, the long and the short of it is, as far as I'm concerned, is the it doesn't have any basis to get involved in divorce and family issues at all. The government
exactly
has no standing to get involved in family issues at all. Right? That said, people are going to have to learn how to govern themselves, right? Quit asking the courts for direction. If you need direction, that's a problem, right? It's, I don't know about you, but I don't need a court to tell me how to wipe my ass in the morning. I don't need to ask them how to pour my cup of coffee in the morning. I think I got that. So, as far as how to communicate properly with my ex-wife when it comes to my children, the answer is I avoid the argument. I just don't be there. If we can't be civil, then guess what? I'm not going to participate in an argument. See how easy that was. So
well, yeah, we do have an exit strategy. It's called grounds for divorce.
yeah.
So when you have grounds for divorce, you have one person that has dirty hands. You have one person, or sometimes it's both, have violated the terms and conditions of the contract or terms and conditions of the marriage. Yes. No. Forget that no-fault divorce. There's no such thing as a no-fault divorce.
That's why I'm saying get rid of the shit.
There is no. That's like saying there's no fault gun shooting.
Right.
Either somebody was irresponsible with a gun or they weren't.
Right.
There is no such thing as a no fault. There's accidents. Yeah, I'll grant that. But you don't have an accident to get a divorce. You have grounds for divorce. See, you keep throwing that no fault around out there, but no fault doesn't mean anything. It is a completely irrelevant term.
Yeah,
You're
it has
married
no standing in law.
That is terms and conditions of the marriage. Till death do you part. Okay, but we're not talking about jurisdiction here. What we're actually talking about here is just marriage in and of itself. So marriage in and of itself has nothing to do with the establishment, support, or management of the government. So there's no such thing as no-fault divorce. You don't get to just decide we don't want to be married anymore, because the terms and conditions of the marriage is till death do you part. You made that sacred vow. Right, again, but you're still talking about court. So I'm not talking about court. I'm talking about marriage. We're not talking about court. We're not talking about jurisdiction. Talking about marriage in and of itself. When you decide to get married, that is till death do you part. That's part of the sacred vow that you make.
That's not the court. That's the Congress. We have to tell the Congress
Right.
that the court has no jurisdiction.
Right.
Because Congress is who writes the judicial action. So we have to go in there and tell Congress, hey, dude, what you're doing, quit doing it. It is hindering public trust, right? Yeah. Right. So basically, I don't know. Can they hear that hissing? I hope not. Okay. Screw court. Court has no jurisdiction. We've already established that. So we have to replace the court. What do you think I'm working on? Unless nothing. There's no unless. There's no unless. Yeah. Unless doesn't even exist. What exists is this thing they've created is based in fiction. It's got no standing in law. And this is the reason that
right.
Jesus. It's like talking to a brick wall. Dude, I'm telling you, they don't have standing, right? There has to be standing in law for the court to take an action. Even the court has said, we don't have any standing here. Quit throwing this at us. And guess what? We're saying, hey, guess what, court? We agree with you. They're saying, good. Go tell Congress that. And that's exactly what we're doing, is we are telling Congress. There is.
What do you think marriage is? Marriage is the contract. Oh, yes, it is. Marriage is the contract. No, it's the same thing, dude. Marriage is a sacred vow till death do you part. And those same grounds that they have adopted are the same grounds that you go before the church and say, look, so-and-so over here was cheating on me. And that's infidelity. Okay. That's grounds for divorce. And you have to go to the church. And what the church does is they say, okay, well, let's go through some counseling here and see if there's going to be some forgiveness here. Because it's
correct. That is the issue. No action. The only thing that happens is the stuff that was acquired during the union, right? That gets divided between the parties, right? Children
it depends on the ground.
Yeah, children are not stuff.
Just because
each according to his or her own situation. Govern yourself. Sometimes the kids are going to go with dad. Sometimes the kids are going to go with mom. No, it doesn't. No, it doesn't.
See, you have to understand the terms and conditions of the marriage. So terms and conditions of the marriage is you're not going to cheat on one another. You're not going to do this. You're not going to do that. That's just kind of a given.
Yeah.
When you do that, acting morally and ethically within your marriage. Okay. And this is where the grounds come.
Right.
Because the grounds are that you have violated morally and ethically the marriage. Now, the one that violates the marriage loses. They don't have any standing to lay claim to the property. Whatever the property is that you're wanting to divide equally, you're not entitled to that because you're the one that violated the terms and conditions of the marriage. Right. You're the one that acted immorally and unethically.
And as far as I'm concerned, in situations like that, because it's happened to me, I didn't want the damn house. I gave it to him. Said, you know what? If you want that shit, you want to be reminded of it, go right ahead. I got something called a life I'm going to go live, and I'm going to enjoy my life.
See, this is the problem we run into.
And that's when the family court said, oh, no, you're not. You're going to pay us this extortion. I said, you can kiss my ass. I'm not paying you jack shit. And now this is, that's when all this started. I said, I'm not going to pay you nothing. You can kiss my rear end. My job as dad is to take care of my kids. I don't have to take care of you attorney, you judge, or even you ex-wife. That's the magic of divorce. I get to go live my life and enjoy supporting and taking care of my children. Because guess what? That's the part I signed up for. So when it comes to what my responsibility is, I know what my responsibility is. I don't need anybody to tell me what that is. Guess what? I'm a grown-ass man. I can handle that. Been doing that a long time. So for the arrogance of these people to come into my life and say, you're going to do this, and you're going to do this, and you're going to do this, I went, and guess what? There's not a damn thing they can do to me. You know, this was me, you know. Now, no fault divorce goes away.
Right. Yeah. No fault divorce needs to go away.
Yeah.
Because what no fault divorce does is it causes the argument. So when you have
creates the division.
Divorce, one's,
right.
You know, claiming the ground.
No, you can't keep it. No, you don't keep it. You don't keep any of it. It goes in the trash can. That's the action the court will endorse. The federal court will endorse throwing it in the trash can. It was a bad idea from the word go.
Yeah.
And me. Yeah. Well, guess what? You can't interfere with their parental rights for any reason. Not without due process of law.
Yeah, marital and parental rights. Those are two separate rights. They're not tied together. Marital rights and parental rights are not tied together.
Correct. So once the
two
marriage,
separate rights.
The only thing left is
freedom of speech and right to be grievances. That's two different rights.
Yeah, exactly. Once the marriage is dissolved, right? The stuff is divided. My solution was take all of it. I don't want it anyway. There, see how easy that was. I care about my children. That's what I care about. And that's the thing that pissed them off about me, because I didn't care about the stuff. I could go buy more stuff. Stuff is easy to replace. I don't care about stuff. You know. Kirk left. He must have blown it. Yeah, I think he lost connection. Oh, there he goes. He's back.
I'm trying to search for a good spot.
Stick your foot in the glove compartment. Grab a hold of that power line above your head.
You see that power line right there?
Right? And stick your tongue in a light socket. There, that'll give you some that'll give you good juice.
Let's see if we can show what the see that mountains over there? See where the snow's still on the top?
Yep.
That's kind of typically where some of the stuff comes from, but that's what we call bogus basin. And it's cold out here right now. It's freaking cold, man.
Oh, I bet. Yeah. You can have that. I love you, brother, but you can have that.
It's not bad. You just got to dress warm.
Yeah.
The thing about with the divorce stuff is, because of the no fault divorce, it causes the fight to fight over the kids. It causes the fight to fight over the property. And so when you bring back the grounds, because you can still file on grounds for divorce. Okay. And I've recommended that to another gentleman, is like, look, you know what? She's the one that messed up. She's the one that took off with the kids. That's called kidnapping, and left the state. That's kidnapping. Now that becomes felony kidnapping. Okay. The one, and it's right even in my own Idaho code. Okay. The one that abandons the family unit loses. That is grounds for divorce.
Yep.
So when you have and establish and claim those grounds for the divorce, that no fault divorce gets kicked to the side because you have grounds for a divorce.
Mm-hmm.
And so the one that has the grounds has to say so on how the property is split up.
Right.
Because the other one has dirty hands. They don't have a right to a cause of action.
Right.
They can't claim shit.
And that was exactly
you're burnt
in my case.
But you messed up. You lose.
Right. And that's exactly what happened in my case.
And to get that back,
as it turned out, again, the
to get that effect, let's talk about buying a car.
Yeah, the dumbass. So because he didn't file the cross and counterclaims like he was supposed to, and come to find out he actually did try, and because the judge wanted the $40,000 emolument, his filing was conveniently misplaced. Well, when I got a hold of it, and I actually got the filing date on it, that actually went to the Judicial Oversight Committee, and man, they went off the rails at that one, because even they said, why the hell didn't this guy tell you this to begin with, right? That was a pertinent piece of information, don't you think? Why did you have to take him to federal court to get him to divulge the fact, oh, wait a minute, he did try this? And my answer was, that's the answer's in the question. Why was that? And the answer was emoluments, money, entitlements. And so entitlements, those aren't a thing. And none of that stuff is a thing. It's constructive fraud, all of it. I hate to be the bearer of bad news, but that's just the way it is.
Yep.
I can hear you, but dude, it's got all kinds of racket on it.
You can hear you.
Yeah. It's never going to happen, Ted. Never going to happen.
There's no such thing as no fault divorce, dude.
Yeah.
That is a scam. That's the fraud.
It's
because till death do you part. That comes in conflict with that. That's repugnant to marriage. No such thing as a no fault divorce. Right. You don't just decide you're not going to make payments on your car and suffer penalties. No. When you decide to stop making payments on your car, they come and repossess your car, and you still have to pay. Right? I mean, there's no such thing as a no fault repo on the car. You still have to pay.
Yep. Well, again, you can hash that and rehash that all day long. But the fact of the matter is, people have the right to enter into any kind of a contract they want. Right?
Right.
Well, where there's
no
marriage, there's dower.
Obligations of contracts.
Right. Where there's marriage, there's dower. Where there's marriage, there's dower. And that's the misconception. There is no license. They can't license. They cannot license a God-given right. Yeah, they can't do that.
That's right.
Because it's got nothing to do with the establishment, support, or management of government. How the hell do you issue a license to get married? No. Well,
let's understand what license is. Let's understand. We need to understand what a license is. License is seeking permission to do a thing that would otherwise be illegal, not unlawful, but illegal.
Right.
So it's a natural right to get married. Okay. So we go back to natural rights and civil rights have nothing to do with the establishment which is the legislative branch, support, which is the executive branch, or management, which would be the judicial branch.
Correct.
Of government. So it has nothing to do with government. It's supposed to be held at the common law.
Right.
And marriage, because it's a religious act protected by the First Amendment and Ninth Amendment,
right?
Okay, you have to go back to the church where you got married. The person who is ordained and established to provide that marriage,
right?
That sacred vow, till death do you part.
Yep.
You know, just like when you buy a car, you have to sign that. Right.
No, you can agree to contract or agree to terminate the contract. However, you want. But there's no liability
in a short time.
Why does there have to be liability because you agree to terminate a contract? No.
If it as long as it's mutually agreeable.
That's the flaw in your logic. You don't have to go before a judge. All you need is
right. As long as it's mutually agreeable, you can draft up your own divorce.
Yes. And a lot of people do it. A lot of people.
You don't have to go to court.
That's the problem. Because you've got the attorneys claiming they have jurisdiction in the federal court is saying, no, you don't. Right? There's the conflict. And here's the problem with that. When the federal court won't step up and go to the lower court, no, you're not going to do this anymore. That's where we're running into a problem. And I have that same problem that you all have, right? You know, it's where is the enforcement of Section 242? It says this bastard can't trespass on my right. You know, Don Refty's got he's not wrong. He's right. So, you know, and that's a problem. Why? Because the monopoly says that, well, we're just going to selectively enforce what we want to selectively enforce. And we don't care if it pisses you off because we know it's going to keep bringing you back and generating more billable hours for us. And I'm like, no, not happening, bro. Not happening. I was born at night, but
it's cold out here. I'm going back inside. So if you lose me, you lose me. But
love you, brother. Yeah, and you got so much white noise, I can barely hear you anyway. So,
yeah,
right. All right, guys, we love you. Remember, stop by our fellow compadres at the other channels all week long. And the tomorrow night is the Far From Normal. Thursday and Sunday is Restoring Families Internet Radio. And always keep your ears to the grindstone for Amelia Durant. She's out there all over the place. So on that note, we love you guys. We'll be back as soon as we get some more answers, because this is fun. At least it is for me.
Yep. Much love to you folks out there. Like, share, follow, all that good stuff. We need to get this education out there. We're still the John Gentry thing there. So hang in there. Chris is doing his work. We're doing our work. We're doing all work. We're buried. Trust me. We're busy. So trying to survive over here and do mechanic work on the side and do law stuff on the other side. And just trying to survive just like the rest of you. So it is what it is. And thanks to Ted for our producer over there. I'm glad he's back. Amen. Running the stuff over there, even though you guys can't hear him out there. So you missed a third of the conversation there, but it is what it is. We'll see you Wednesday.
Absolutely.
Much love, brothers and sisters.
Amen.
Make America great again. Here we go.